Good morning,
Conference will now be recorded.
everyone. Special Magistrate Code Enforcement hearing. It is by Verizon's time, 10 o'clock. My name is Amity Barnard. I'm the Special Magistrate for this morning's hearing. First thing I'm going to do is, if you're here for a code enforcement matter, I'm going to swear anybody in who's here to testify on any items that are on today's agenda. So if you're here for an agenda item, if you could stand if you're able and raise your right hands for me. Yep, if you're here for code enforcement, you're in the right place. Raise your right hands for me. Do you all swear or affirm to tell the truth, the whole truth, and nothing but the truth? Thank you. You may be seated. So a little bit about process. Looks like the agenda has, I think, predominantly violation hearings, and it looks like maybe one fine challenge. So with the exclusion of the fine challenge, the violation hearings will proceed in a manner that you'll hear the town put on its case first. You'll hear, typically the town calls these cases in order that they appear on the agenda. So once you hear your case called, the town will put on its case, any evidence that the town has. Any witnesses that the town intends to call will be heard at that time. Once the town is finished presenting its case, you will then get an opportunity to come to the podium that's right in front of me here, present any evidence you have, any testimony you have, cross-examine any witnesses that the town has put on. And at the end of that dialogue, I will make a final ruling that you'll get an order in the mail that reflects. So with that, I will remind everyone that your testimony here today is given under oath. So with that, I'll turn it to the town to call its first case. Noting for the record that I did review the January 7th, I'm not going to miss it today, 2025 meeting minutes, and they are approved as written.
Thank you, Your Honor. Chris Gow on behalf of the town of Ocean Ridge. Your Honor, the first case we have today is case number 2025-01. This is a traffic citation. Rachel Mueller is the respondent in this case. Our officer was not able to make it this morning, so we're going to go ahead and dismiss that case on the record.
Okay.
Ms. Mueller is present, and I advised her that we would be dismissing the matter.
Okay, so essentially you don't need an order dismissing, you're just dismissing it outright and pulling it from the agenda. Okay, Ms. Mueller, that's you?
Yeah.
All right, so they've dismissed you. Have a nice day. All right, thank you.
All right, Your Honor, the second case is case 2024-023. The property address is 20 Hudson in the town of Ocean Ridge. Property owner is Ocean Ridge Family LLC. This is a fine challenge hearing. As you may recall, this order for this property was entered at the December 3rd, 2024 hearing. It was a finding of an irreparable violation with a violation of section 67-118 dealing with the expiration of a fill permit. The request to challenge the fine was timely made to the town clerk. The order is included in the backup materials, and as you may recall, the order was for commencing December 3rd, $2,000 per day as an irreparable violation. I believe we have an attorney here to address the fine challenge.
All right, who's here for this one? Good morning, sir. Your name for me, please?
Sean Swartz.
And your counsel for the LLC?
Correct.
Okay. Go ahead, sir.
Yeah, just, this is a request for a reduction. The property owner requested an extension from 352-363, the emergency order, on the October 28th, and that was prior to the expiration of the permit on the 30th. The statute allows 90 days from the termination. It allows 90 days from the termination of the EO, which occurred on December 20th, 2024. So they would have 90 days from December 20th in order to extend that permit 4 years under the statute.
And Your Honor, the town's position on that was we had already served him with the notice of violation for this case prior to that request being received, and pursuant to the statute, the extension under the emergency order is only to occur if there hasn't been the issuance of either a warning or notice of violation for being in violation of the code. And so that had already been issued, so the town denied that request for an extension under the emergency order statute.
Do you have that statute handy?
I do.
You have it?
Perfect. Show it to the town attorney before you present it to me first, thank you. Thank you. So, Mr. Schwartz, what's your response? It looks like in D3 here, it says that this subsection does not apply to the holder of a permit or other authorization is determined by the authorizing agency to be in significant noncompliance with the conditions of the permit or other authorization through issuance of a warning letter or notice of violation, the initiation of formal enforcement or an equivalent action. What's your
The
response?
only violation was for the expiration of the permit, which is exactly what the statute's going to extend. The emergency orders hadn't even terminated when the request was made.
Right, but I think the town's position is that they had already issued your client a notice of violation.
After the initial request, 2 days. The initial request for an extension came in on the 28th. The
He
denial.
didn't make it under the statute. He
Correct.
made it a
He made
request
it, correct,
for an extension of the permit.
Who's he, just so I'm
the
following
property
along?
owner.
Okay,
And the problem is, and this was what we discussed in the December hearing, is under the town's code, there's 180 days to do your lot clearing. You are entitled to 1 day, 30-day extension. After that point, after 210 days, there's no further authorization to permit the work.
and this was the case where the town inadvertently gave them too much time, is that?
Yes,
Is that this
instead of
case?
an automatic 30 days, he was given 90 more days to complete it, so a total of 270 days to complete it. What he initially requested was a further extension of that permit timeframe, and he was told, we can't, under the code, give you any further time because your permit has already expired, or is expiring as of the date. And so, knowing that the work was not going to be completed in a timely manner, the town issued the notice of violation. Then he came forward with a request under the statute for an extension.
And when was that relative to the December hearing? Because this did not come up at the violation
Correct.
hearing, correct?
Correct. It was before the hearing.
Okay,
He requested it, but at that point, our position was we had already issued you the notice of violation, and per the statute, once the notice of violation and even a warning notice was issued, there's plenty of emails that arguably are a warning notice to the property owner that he was going to be in violation of the deadline to complete the work.
and Mr. Schwartz, you were not present at the December hearing, so were you retained after?
Correct.
Okay,
Mhm.
because there was somebody here at the hearing, I'm looking at the previous order.
I believe it's the property owner's wife, she's part of the owners.
Miss Russell, Tricia Russell?
Correct.
She's the spouse?
Correct.
Okay. So what's the ask here? Is this, I heard, the agenda says that this is a fine challenge, but your words were that this is a fine reduction
Correct,
request?
that's what we request. We would request 3 days, so $750.
3 days of,
Under 3 days under the section of the code that provides that a first-time violation is $250.
okay.
Because this was issued as a daily fine, however, it was determined in the original order that it was irreparable and irreversible. So if it's irreparable and irreversible, how can you have a daily fine to correct something that's not repairable? So that was our position.
And Your Honor, I will say this, I've talked to 3 different attorneys on this case. One of the issues, we did go under irreparable for this violation because of the fact that the town's code doesn't allow for any further extension of time. It was pointed out to me under 162.09, the Florida statutes, that the irreparable violation of $5,000 is a flat fee of $5,000. I took a look at that. I think there's an argument that with this type of situation, that because there's no way to give the property owner an additional permit, it's irreparable, but that would then require the town to every day issue a new notice of violations. So the town is agreeable to reducing the total fine to $5,000.
What's the current fine as we sit here today?
It's
What's the fine?
$8,000, so with it commencing on December 3rd at $2,000 a day, and then each day it would took 4 days to complete the project.
Okay, so 4 days of non-compliance essentially.
Yes.
So $8,000 plus administrative costs. I
Correct.
presume that were in the prior order.
Yeah.
What's your response, sir, to the?
Well, like the $8,000 would be in conflict with 16209, because it would be more, even if you call it irreversible and irreparable, which section 67-12 of the code provides for a $250 fee for expired building permits, which a fill permit is under the Florida Building Code. So I would, and the fill permit section of the code is silent.
Your Honor, the town's fill permit, while issued by the building official, is not technically a building permit. It's just a fill permit. It's authorized to be issued by the town's administrative official. It is a development order, but it's not a building permit. And it's one of those things, sort of like the town has a local duration for construction. So the issue is, once that duration runs, the town can no longer issue a permit. So technically, every day you're in violation of working without a permit, and there's no way to really cure it.
That was my recollection from the December hearing, is that I didn't have the latitude to give additional time to comply because the time to run had already ceased.
Correct.
And in fact, more time than was supposed to be allowed under the town's code had already ceased to run. So,
Yeah.
But I guess I want to be careful here, because if this is,
I mean, they came into compliance 3 or 4 days later. I mean, it's not as if, and they made that request under 252-363. They finished the work 3 days after the initial hearing. I have some other documentation showing like the amount of time given and then the amount of fines for similar type cases. There's a property, 21 Hudson across the street, same situation, $250 a day. Expired fill permit.
well, I hear what you're saying, but just appreciate the fact that every case is a little bit
I
different.
get
So,
it. I understand.
but what happened here is what happened here. My concern is that the time to make these arguments was at the December hearing. The time is not now. So
I get it.
while I understand you were retained after that hearing, somebody was here, and if there was a dispute as to the legal sufficiency or the legal appropriateness of that fine amount, that was the time, and your client certainly had appellate rights under that order. What happened? Were you supposed to be here at the last hearing? No.
I was just retained last week.
So another attorney was supposed to be here at the last hearing?
The property owner was supposed to be here at the last hearing. They requested the fine challenge, and they didn't show up, so you went ahead and continued it to the day.
That I remember, that although I wasn't comfortable proceeding with the matter at the last month's hearing, because there was nobody here to be heard.
If we could request a reduction in the alternative of challenging the fine, I mean, that would be appreciated.
I guess what's the town's response, is this is listed as a fine challenge? Is the town,
Your Honor, yeah, the burden's on the respondent pursuant to the town's code to establish just cause for a reduction in the fine amount that was imposed pursuant to your order. The town is agreeable to reducing the fine amount to $5,000 pursuant to 16209 of the Florida statute. But beyond that, the town doesn't find any cause for the fine to be reduced further than that.
and in essence, you would be agreeing to that's essentially one 1 day's fine at the maximum for an irreparable, irreversible violation.
Correct.
What's the town's position as it relates to administrative costs?
The administrative costs are still the administrative costs because the violation was found.
And they remain outstanding?
Yes.
Okay. All right, what's your response, sir?
I think that the original fine was $2,000 with a daily, which we've now learned is in conflict with 16209. So I would think at the very least, we could go down to $2,000. That was the initial fine. That was what was determined was irreparable. The daily is just added on there in addition. Because the statute either, in the code, either allows $250 and daily, or up to $5,000 and irreparable, and this one was $2,000 and irreparable. So at the very least, I'd request the $2,000, but I mean, ideally we'd want, as any other expired building permit, $250 a day, 3 days, $750.
Well, I don't think you're entitled to that. I mean, the way that this was cited, this was an irreparable, irreversible violation. So again, challenging the merits of that, this is not the hearing to do that. Whether you were to pursue an appeal or whether somebody was to come to that hearing and make that argument then, this is not the time to make that argument, nor is it the time, if your ask is for fine mitigation, to challenge the validity of the daily fine.
Correct.
That time you have appellate rights under the previous order. This is not that hearing. So I'm amenable to reducing the fine. You tell me if you want a fine reduction. I'm not inclined to find in your favor based on the facts that have been presented this morning. I don't find that the tolling of development order pursuant to this statute applies, given the notice that was issued in this case. So I don't think that argument under 252-363 is appropriate.
But the only notice of violation was for an expired permit, which is exactly what that statute is seeking to extend, which allows up to 90 days from the termination of the executive order to file
I
that.
understand that. I understand that very clearly, but what I also understand is that there's an express carve-out for this exact scenario where you've been issued a notice of violation. So I don't, in my mind, this part of the statute that you're trying to rely on doesn't apply here, given where you were and where your client was and the fact that a notice of violation had already been issued. That said, I'm willing to reduce the fine. My job here is not to be punitive, but my recollection of the December hearing is that, and just like any other case, I mean, there's only 3 cases on today's agenda. The town doesn't usually have a very lengthy docket. Cases that get to me, there's usually a reason that they're getting to me. So again, without going into the merits of what was discussed at the December hearing, there was ample time for compliance within the time that was allotted by the town.
Yeah.
That didn't happen.
Well,
so
They
go
have
ahead.
another contention that the 90 days was not sufficient for them to, from the beginning, the amount of time that they were issued under the fill permit was impossible to comply.
I understand that, but whether they think it's sufficient doesn't matter. What the town code says is
I got
what
you.
controls. So if the town code says the town commission can only grant a 30-day extension, it doesn't matter if your client agrees with that position or not, that's what the code allows. So I appreciate your argument, but again, I don't think that the ability of the respondent to think that that's reasonable doesn't matter here today. So what does matter is what's allowed by code and what was ultimately done to get into compliance. So let me ask both parties before I make a ruling if there's anything else you'd like me to hear. Town?
There you
Sir, Mr. Schwartz, anything further?
No, ma'am.
Okay. Let me ask the town procedurally, do you want, are you asking for a record to be entered in today's hearing, in today's case? Do you want the evidentiary case file, some documents
Yes,
before
Your
me?
Honor, what is presented based on what's in the agenda for the backup for today, which includes the request for hearing, the order from the December hearing, the continuance of hearing, which was entered last month, the request for the fine challenge, and the town clerk's statement as to the fine due as of January 28th of 2025.
All right, Mr. Schwartz, you've seen those documents scrolling on the screen. Do you have any objection to those documents being entered?
No.
Okay, and you're not contesting that the total fine amount is correct, right? You're in agreement with the $8,000?
No, well, that's one of, under 62 point, yeah.
Right. The calculation
You mean
under the prior
math-wise.
order, yes, mathematically under the prior order, you're not disputing that. Okay, so no objection to the documents being entered?
No.
Okay. And then as it relates to service, there is no, let me just double check that. This was respondent requested, correct? There was no notice document sent?
I did send the continuance to them, and I emailed it to them, and they did acknowledge it,
Okay.
I did attach that in there.
Okay. All right. All right, in case 2024-023, I'm gonna enter the town's evidentiary case file, which has been shown to respondents counsel. I'm also gonna include a copy of chapter 252.363. I'm gonna mark that as R2. I'll enter the town's evidentiary case file without objection by respondents counsel as composite exhibit 1. I'll enter a copy of 252.363 as exhibit R2 without objection by the town. So the record is clear, the respondent requested this hearing, so apart from the prior order granting continuance from the January 7, 2025 hearing, which was sent because respondent's client did not appear at that January hearing despite having requested the hearing, I'll find that respondent is present and proceeded under the original request, which was made prior to the January hearing. Based on review of the documents in the case file, which include the prior order from December, as well as 252.363 and the testimony on both sides, I'll find that 252.363, the argument as it relates to the tolling of development orders, is not applicable given the notice of violation that was issued in this matter, which is expressly exempted from that tolling provision. I will grant the requested mitigation of fine, and I'll reduce the previous fine amount from $8,000 down to $5,000. And I will reaffirm the administrative costs for the December hearing in the amount of $173.96 payable within 30 days. All right, so you'll get an order that reflects that in the mail, okay?
Thank you.
And Madam Clerk, let me ask that you put this in the town's case file after the hearing, please. All right, next.
Thank you, Your Honor. This is case 2024-029. The property address at issue is 81 Island Drive South. Property owner, according to the property appraiser's office, is Jay Walshine. Your Honor, this case was on the agenda for last January, the hearing in January. It was continued at the request of the respondent's attorney who was present. We have for the town clerk present to testify, along with representatives of the town's building division, who also serve as the town's code enforcement staff. This case was originally cited as an outdoor storage violation for construction materials. That case was dismissed. It appeared on your January agenda. That case was dismissed. So the case that we're proceeding under today is the one on the agenda for violation of work without permits. In the backup agenda item, we do have the information regarding the original case for outdoor storage, along with the photographs taken at that time, along with the NOV issued for the work without permits.
All right, you indicated you have additional town witnesses to call?
Yes.
Before we do that, if I might, I hate to interject. My name is R. Max Loman from Loman Law Group. I'm here. I'm Mr. Walshine's attorney. I already shared this argument with Ms. Gatto. I object to their testimony, the building official testimony. He invaded Mr. Walshine's curtilage in violation of his 4th and 15th Amendments right to gain the information that precipitated this NOV. And his testimony is barred. You can't allow him to testify about what he saw when the information was illegally gained. Building official nor a code officer has the right to invade curtilage on the suspicion that work is being done. You have to have a warrant, or there has to be exigent circumstances. There is more than sufficient federal and state case law to support that. The curtilage of the home is afforded the exact same entitlement.
So before you go further, let me hear any other witnesses the town intends to call besides the building official before you proceed with your testimony, okay?
As long as it's not testimony about any information that was gained pursuant to, if it was gained independently from them, not from the property, that's fine. So if your clerk has.
Yeah, I don't know who the town intends to call, so let me ask them who their additional witnesses are, because the town presents its case first, and then you get your
Sure.
opportunity to present. So I hear your objection. Let me ask the town for any additional witnesses that it intends to call.
Your Honor, we do have the building official who's present, but we also have the building inspector, community standards officer who issued the NOV, Steve, pronounce your last name? Shane, who's present as well.
And that testimony is related to notice?
The notice of the violation and the observation made on the property. We also have a building inspector who actually, I believe, is the one that Mr. Lohman objects to his testimony.
No, it's Mr. Shanks. His name's on the order. He's the one that came onto the property and invaded Mr. Walshine's curtilage.
No, that's two different people.
No, he's on video going on the property. This gentleman right here in the blue shirt.
He didn't issue the NOV.
His name's signed on it.
No, that's two different people.
Well, that's another issue.
All right, let me hear the testimony as it relates to service of today's document. Notice of violation and any documents the town intends to rely on in terms of service. Who's testifying as to that?
It says right here, affidavit of service, Steve Shane.
Yes, we have Steve Shane who's going to testify as to the service of the NOV.
Right, and it also says that he's the one that personally observed the violation. Yeah, that's the testimony that I object to, because it was obtained illegally.
There's two different people. There's the notice of violation that was issued based on observations at the property.
Okay.
There's also an observation that was made based on an open building permit by the building inspector.
Okay. And who made that observation? The second one.
Our building inspector, who's also present.
And what's his name?
Louis Miller.
Okay. All right. So this affidavit states that, this doesn't state that the person observed the violation, it states that they posted the property. So that's not what you're arguing.
Mm-hmm.
Right, so
It's not.
then let me hear from the person who completed the affidavit of service and posted the property.
That's the same person. The names match, Steve Shane. He's the person that says he observed the violation. That's right on the front of the NOV. And then on the affidavit of service, and it is notarized sworn statement saying that
Your Honor,
he's
perhaps,
got an affidavit of service.
It
signed
says
by
he
him.
posted the property, it doesn't say that he witnessed the violation, it's
Yes,
just,
it does. It's right
Your
on
Honor,
the
I think
front.
he's talking about the first page of the notice of violation. Perhaps we could have Mr. Sheehan testify as to what he observed at the property.
No, that's exactly what I am objecting to. Because he gained that information by violating the curtilage of Mr. Walshine's property. That is the basis for this violation. Construction materials sitting in a driveway do not constitute a violation if they ever get a building permit. Actually, seeing somebody do work on the property for which they don't have a permit is what he was cited for. It doesn't even say what work was being done that they were cited for. The affidavit and notice of violation, the NOV, the notice of violation to initiate this, was issued by Mr. Shahin. He's got an affidavit of notice of violation notarized by him, and then an affidavit of service saying he served the notice of violation. And the notice of violation itself is chalked with errors because there was no time given to comply.
Well, but
Which is
so
a
now you're
violation
getting-
of
I understand that,
162.
Mr. Lohman, but you're asking me to make a determination without letting me hear the evidence. So I don't understand what you're expecting me to do here. You're not allowing me to hear the testimony as it relates to service to the case or the documents that are in the case file. So how am I supposed to make a ruling if you're objecting to everything coming in?
Because
everybody's
because
speaking.
the very basis for the violation was the very basis for the issuance of this NOV was a violation of Mr. Walshan's constitutional rights.
But
And
none
so
of
you're
that
not
has
letting
been-
me, you don't want to hear that basically
That's
Ortaga's
not
motion.
what I'm saying,
You want to
sir.
allow him to testify.
What is your motion, sir?
I was making it, that this notice of violation and the allegations itself should be excluded because they're basically, I hate this phrase, but it's the fruit of the poisonous tree. He violated the curtilage of the property for the basis of this violation. He's the one that issued the violation. This is the only allegation in here. And he wears two hats apparently, which is questionable in the town. Reports the contract building inspection services as well as contract code enforcement as a CSO. But neither a CSO nor a building inspector may conduct warrantless searches of Mr. Walshine's property. And that's exactly what happened here. He walked through a latched gate into the backyard.
Have I heard that testimony?
You will.
Will I? So that's what I'm saying. You're asking me to make a determination with no evidence in the record. I understand your legal arguments, but again, let me go back to what is your specific motion? What is the motion that you're putting forth?
I think his testimony should be excluded for violating Mr. Walshine's Fourth
And when you
Amendment
say
rights.
he, you mean who?
Mr. Shahin.
Okay. What about Mr. Miller?
This is the first time hearing about Mr. Miller.
All right, any other motions to be considered?
Not at this time. Well, I have an issue with the actual legal sufficiency of the notice of violation itself. I'll make that argument later.
Okay. What is the town's response to Mr. Lohman's motion?
Your Honor, I believe we have two different individuals, and it may be two different cases that are being confused or confounded. From the town's perspective, we should hear from the individual who issued the NOV as to his procedure and process. Perhaps he did not observe work without permit. Perhaps he just observed the appearance of construction materials and construction workers at the site, which the town may utilize to establish the violation. There may be another individual who was there for another purpose who observed the actual work without a permit, but until Your Honor can hear that evidence and make a determination as to who did what and who saw what, I don't think you can rule on the motion without hearing that evidence.
I understand that argument, but if I may, if you stand up and look at this document, it says that he personally observed work being done without a permit on November 22nd. That's what Mr. Walshine is being cited for. He's not being cited for work being done without a permit on the 21st or the 23rd or the 24th or December 1st or today. So testimony about what anybody else saw any other day as it relates to this notice of violation and this violation is completely and utterly immaterial. It has nothing to do with what he's being cited for. He was cited for, and more importantly, Mr. Shahin's notice of violation says that he personally observed work being done without a permit.
Your Honor, that's not what the NOV says. What the NOV says is that this violation notice is based upon personal observation / investigation. Witness affidavit, if any, must be attached here too. The legal description of the property, blah, blah, blah. It does not address, say, what Mr. Lohan is representing to this court. Sorry.
And it doesn't say or upon a witness. It says personal observation investigation. And it says you were notified on 11/22 to stop working. Stop working. That means you have to see someone working, not construction materials on a property. You have to see somebody working. You will need to obtain a permit in order to work on the property. And then it says obtain the permit immediately.
So I
Which is not
understand that.
sufficient time to comply.
Okay, that's a whole nother legal argument, but in order for me to get there, I have to hear some testimony and I have to review these documents. So I'm gonna let at least the person that sent the notice of violation and that produced the affidavit of posting, which is in the case file, I'm gonna allow that testimony over the objection of Mr. Lohman. So, Mr. Lohman, you can continue to stand there. I'll ask that the witness who presented the affidavit of service come to the chair over here to my left and present their appearance, and then give me the testimony as it relates to service for these documents.
If I might, I would just request again that his testimony be limited to process and procedure in his actions, not what he saw.
Go ahead, sir, your name?
Steve Shane.
Yes,
Is it all right?
If it's red, it's on.
Okay. Steve Shane,
Spell your last name for me, please,
Shahin,
and your position with the town?
code enforcement.
Okay, go ahead. I guess give me your testimony as it relates to the documents in the case file, the notice documents for today's hearing.
My first day of employment was December 2nd, and I was training with another individual, and that's when we took those pictures, I believe, that was on the screen earlier. And anything in November, I was not there. And I did not go on his property. Excuse me, I did not go on his property December 2nd. The pictures were taken from the street. I've never been on his property.
All right, and did you prepare the affidavit of service that's in the case file? Can you scroll that to that on the screen, Madam Clerk, please? So can you explain the posting that you did?
Yes, I was advised because I was training with another individual, and we had a situation where there was work being done without a permit. And we took the pictures and proceeded to do the NOV. And as you can see, when the pictures were from the street.
And the pictures that you're referencing, are they those photographs?
Actually, that one's in the car. You can see the rear view mirror. But like I said, I was advised.
Right, is there anything else that the town would like to ask this witness?
Did you, before filling out the affidavit and notice of violation, talk with anyone with the town regarding this matter?
The person who was training me,
Okay, who's that person?
Manny, I don't know his last name.
Okay, Manny Palacios?
Yes.
Okay. Do you know if Manny or anyone else spoke with anyone else with the town or with your organization about this case?
I'm not aware. I was just with Manny, and I was being advised from him. And I ended up writing it up.
Okay. Nothing further, Your Honor?
All right, Mr. Lohman, any cross-examination
Yes.
of this witness? Oh, sir, hold on. Please see that Mr. Lohman gets an opportunity to cross-examine you, okay?
So you said you wrote it up. Could we page back up so the response, so the witness can see the affidavit and notice of violation? I think it's the first page. Said you wrote it up, so you issued the affidavit and notice of violation. Is that correct?
Correct.
Could you go to page 2, please? And now there we go. Thank you. And so is that your signature?
Yes.
Okay, so you filled out this whole form and it was notarized. It shows here on the document. It speaks for itself. December 2nd, correct?
Correct.
So it says here, check personal observation. What did you personally observe on November 22nd?
Just like the picture showed, construction materials and people working.
You personally observed that on November 22nd?
Yes.
You said your first day?
No, not November 22nd. Excuse me. December
Right.
2nd was my first day.
Right, so you didn't personally observe anything at 81 Island Drive on November 22nd?
Nope.
Okay, so, but you swore that you did. It's just a sworn affidavit. You know that's a false juror, right?
Your Honor, objection. It's not, he says at the beginning of the affidavit, swears that he has just and reasonable grounds to believe and does believe that on 11/22/24, that observation existed. And then he's checked personal observation / investigation.
All right, I'm gonna allow Mr. Lohman to continue. I note the objection, but go ahead, Mr. Lohman.
Yeah, I mean, you can see the problem here. Chapter 162 says when the code officer observes a violation. It doesn't say when the code officer takes photographs of another, observes photographs that someone else took. There's the very definition of hearsay. You can't fill out an affidavit and say, it says personal observation investigation. If it was purely investigation, he should have scratched out personal observation. It is a false juror. He swore to something he did not see personally. He did not personally observe anything on November 22nd at 81 Island Drive. And then to add insult to injury, we turn over and as chapter 162.06 subparagraph 2 says that once you observe a violation, you are required to then, you issue the notice of violation and you are required to give the alleged violator a reasonable time to comply. What's immediately? Immediately just passed. Now it's immediately again. And a second later, it's going to be immediately. Mr. Walshine wasn't even if he was guilty of this violation, he wasn't given an opportunity to comply. Because it says immediately. How do you comply immediately? You immediately, when it was served him, the violation was purportedly observed on November 22nd, but it wasn't issued till December 2nd. But my client was ordered to comply immediately. You see the problem there?
I hear your arguments. Go ahead and continue with your cross-examination of the witness. That appears to be a second legal argument, but I hear what you're saying.
If I may respond to
Go
the
ahead.
first legal argument.
Well, let me reserve on that. So make a note and let's come back to that because we're getting off cross-examination and into Mr. Lohman's legal arguments as it relates to sufficiency of the documents. That doesn't have anything to do with the cross-examination of this gentleman. So go ahead and finish with your cross-examination, please.
So you filled out this form, correct? That's what it says here.
Yes.
So immediately, is that a reasonable time to comply? Can you get a building permit immediately?
I never tried. I never gotten a permit. That's not my forte. I'm code.
So, but as a code officer, do you think immediately is a reasonable time?
No.
Okay, so let the record reflect that the witness said no, immediately was not a reasonable time. I have no further questions at this time.
Your Honor, may I?
Yes, go ahead.
The affidavit you entered said based on the original date of November 22nd, 2024. Do you know what happened on November 22nd, 2024?
Not exactly. I was just told.
Objection, hearsay.
No, I don't.
Okay, Your Honor, if I may address the hearsay objection.
Go ahead.
We are not under strict rules of evidence in this hearing, and hearsay evidence can be allowed if it's corroborated. So I would ask for him to say what he was told, and if I have corroborating evidence, it should be allowed since we're not under strict rules of evidence.
I agree with the application of the less than strict application of the rules of evidence. So go ahead and proceed over objection.
I was on my first day, December 2nd, I was told about the history of the situations that was arise at 81. And it was verbal from Mr. Palacios of because he was the original person who I believe was dealing with this. So he was just updating me of what was happening at 81.
Okay, and based on your recollection, did something occur on November 22nd, 2024 regarding the same materials that you took a picture of at this property?
I don't know the exact date, but he told me, yes, that there was materials and stuff. I just don't know the exact date. But he was
So for the record, he is Mr.
the
Palacios.
materials that was delivered there.
You're asking who is he? Who is the he you're referring to?
Mr. Palacios.
Okay, thank you.
Is Mr. Palacios here?
Mr. Palacios is not here right now.
Well,
Again, I've admitted that the formal rules of evidence do not strictly apply in this
I know,
code
but now I don't
enforcement
have an opportunity to cross-examine Mr. Palacios. He's saying what Mr. Palacios told him. Mr. Palacios isn't here to corroborate what he told him. I know that the strict rules of evidence don't apply, but it still has to be reasonable and it has to be material. And when you're just taking, well, somebody told me this, and so I did X. And Mr. Palacios observed it, he should have written it himself. But this is, how are our procedural due process rights being afforded here when I don't have an opportunity to cross-examine Mr. Palacios? He's not here. I can't verify whether or not what this gentleman is saying, and I know he's under oath, but I
Yeah,
can't
he's-
verify what he's
yeah.
saying against Mr. Palacios' testimony.
I understand that, so that, I've already admitted over objection what amounts to hearsay that was told to this gentleman by Mr. Palacios. So to the extent there's no more testimony about that, I think I've heard enough as it relates to how he found out about whatever happened on November 22nd. Go ahead with any additional questions for this witness.
Okay, so when you issued the notice of violation and required immediate compliance, was that based on events that were told to you that transpired before your involvement?
Correct.
And nothing further, Your Honor.
All right, Mr. Lohman, any follow-up?
Yes, I read right. So immediate, I'm trying to figure out what immediate was based on because that was kind of obtuse. Based on events that occurred before your involvement immediately, you just testified that as a code officer, you don't believe that immediately is a reasonable time to comply. Was this cited as an irreversible or irreversible violation?
I don't understand the question.
But he's your code officer, and he doesn't know the difference between a daily violation. I can ask about public health, safety, and welfare and repeats as well. But he clearly doesn't understand Chapter 162, but he's the person issuing violations, and then he's also testified that immediately is not a reasonable period of time.
Yes, Mr. Lohman, I heard that very clearly. So proceed with any additional questions you have for him.
I'm finished with this witness.
Okay. All right, you can step down, sir. Any additional witnesses that the town is intending to call?
Your Honor, we would call Mr. Miller, who was present. And I believe Mr. Lewis Miller's testimony is the testimony that Mr. Lohman initially stated his objection to based on a Fourth Amendment violation.
Is Mr. Miller the building official?
Building inspector.
Okay. Was it your objection, Mr. Lohman, to the building official?
It's the building inspector, yes, Mr. Miller. I mistook him for Mr. Shaheen.
Okay. All right, I'm going to admit Mr. Miller's testimony over objection. Again, in order for me to rule on the facts, I have to hear the facts. So, Mr. Miller, please approach.
My leg fell asleep. Wow.
Oh, you need it though.
Wow.
All
Okay.
right.
Yeah, it's a heavy leg. Okay.
Your name, sir,
Lewis Miller,
and your position with the town?
City Inspector.
Okay, thank you.
Mr. Miller, are you familiar with the property at 81 Island Drive South?
Yes, I am.
Okay, and how are you familiar with that property?
I entered the property, the gate was open, was pried open with windows that were being installed, so they had a permit for the windows.
On
So
what
when,
date? On what date?
whenever I issued the stop
Mr.
work order, I
Yeah,
don't
Yes,
remember.
perhaps after
Mr.
I finish my
Lohman, let the
direct.
town attorney question her witness, and then you will get an opportunity to cross-examine and ask any follow-up questions you have.
I'm sorry, go ahead.
I believe the work order, the stop work order that I issued has a date on it, and it states that they were working without a permit. I entered the property, I saw people working in the back, cutting tiles, cutting the pavers, installing pavers, and I asked them where the permit was. They didn't speak any English. A couple minutes later, the owner came out with a video, started videoing everything. What are you doing on my property? Get off my property. Get off my property. He was videoing everything. You entered my property, I had a locked gate. The gate was pried wide open. So that was my statement.
Okay, when you went to the property, what purpose did you go to the property?
I was under the impression that there was work being done without a permit. So I approached the property. I saw the windows were against the fence, held open. So I entered the property, I saw people working. That's pretty much it.
And what was the date that, do you recall?
Don't remember, it's on the stop work order. I don't recall the date.
And Did you have a conversation with anyone before you went to the property regarding the potential for work being done without a permit?
My boss, Michael, asked me to just get over there and just take a peek and see what's going on. So I
Okay.
did.
In terms of the windows being propped up against the fence, did they have a permit for windows?
Yes, they did.
Okay, and was that permit active at the time?
Yes, it was.
And were folks there installing the windows at
Yes,
that time?
yes, they were.
Okay. Were they installing anything else?
No, not the window people.
Okay. Were other people there installing something else?
Yes, they were installing pavers.
Okay. When you approached the property, did you see those pavers?
Yes, I did.
Where were they located?
In the front and in the back.
And after you observed this at the property, did you have a chance to look at the building permits that were issued for the property?
No, I did not. I just saw that the owner came out with the permit for the windows, and that was it. But no, I didn't physically examine everything, no.
Nothing further at this time, Your Honor.
All right, Mr. Lohman, do you have any cross-examination for Mr. Miller?
Yes, I do. Before I do that, I move that the entirety of his testimony be stricken. We don't even know what date it is. How am I supposed to, I mean, he can't even testify to what date he was on the property. And then again, whether the gate was propped open as he says, which I'm not gonna argue that at this particular moment, or not, that's not an invitation to invade someone's curtilage because you're under the impression. So did you see any work from the street? Was it observable that they were working in the backyard?
No, I could not see from the street.
Did you obtain a warrant?
Didn't know I needed a warrant, sir. Why would I need a warrant? I'm in there doing an inspection.
Did somebody call for an inspection?
Well, I was under the impression that the windows were being installed, so I went over to just check and see how the progress was going. At the same token, I saw people working in the back.
So you are under the opinion that if a building permit is open, you can just come on somebody's property and invade their curtilage anytime you want?
I wouldn't say anything, no, sir.
So you can go on their property anytime you want?
No, sir, I'm not just going in property, but if I'm there to do an inspection, just to check on it, I think that's my privilege.
Did somebody call for an inspection?
No, sir.
So what authority do you have to do an impromptu inspection because you feel like it?
I don't have authority because I feel like it, sir. My new responsibility is to fulfill that obligation, to make sure that if work is being done, then it's being done proper with a permit. If it's not with a permit, then it should be notified somebody. That's why you should
Well,
stop work.
the town has records of building permits, correct?
Yes,
So if you were there under the guise of doing a window permit inspection to see if there was a permit, you just said that, you were doing it to see if there's a permit, the town would already know that there was a permit. You wouldn't have to go on the property to see if there's a permit.
it'd be nice to go out there and make sure that they're installing it properly, is one question, but that's not what was there.
So why were you there?
I was there to see if there was work being done without a permit, sir.
What work?
The papers.
So you went out to the property, you weren't there under the guise of doing a window inspection like you just said a minute ago.
No, I wasn't doing an inspection for them, sir. I
You
didn't
just
say-
said that, you
No.
just said you went out there because you were gonna check on the windows and make sure they were being installed
I
properly.
understood there was a permit issued, so at the same token, I was looking at the windows while I was out there. That's what I was doing. But
Oh,
that's
simultaneously,
not-
what did you inspect on the windows?
Well, I was looking to see if they had the right windows in. I was looking at some of the butts, some of the installation. It's called work in progress.
What do you mean the right windows?
Well, you have certain windows that have to meet the NOAs. I didn't verify the NOAs, but I was looking at the windows, just looking to see if they had windows they were putting in, and everything was going smooth.
So now it's your testimony, you were there doing a window inspection again.
No, I'm not doing a window inspection. I happened to notice it while I was there.
Oh, okay, so a minute ago, originally, your original testimony was that you were going out there to do a window inspection.
No,
Yes, that's exactly what you said. I mean, we got this on recording. You said that you were out there to do a window inspection, and then you turned around, initially, when you were being on direct, you said that you were there, because you went on the property because you were under the impression.
I was asked to go to the property.
Right, because you said you were under the impression that work was being done.
I just figured put it
Okay.
in that way.
If you were under the impression that work was being done inside Mr. Walshine's home, and the door was open, do you think, is it your opinion that as a building inspector, you have the authority to just walk in the
No, I
house?
do not.
So, but you don't realize that the curtilage of his property is the same under the US Constitution as inside his house?
When I saw an open gate, sir, that's when I figured I said, I'll walk into the property.
Is it,
With the gate open, and if you look at the footage on the film of me walking with this gentleman, unless he erased it, you'll see that the gate is propped open. So just look at the footage of the camera.
but I just asked you if the door was open, could you walk in the
I
front?
did
house?
not say I was walking into a
No,
door.
I asked
would
you,
not go into a doorway, sir.
if you would walk
I
in
would
the
knock
house.
on it, I would knock on the door, I would not walk into a house. If it was a vacant house, I would walk in, yes.
But if it's a house,
I would not walk into a house that's occupied. I would knock on the door.
so if the door was open and no one was home, you'd walk in?
I just said, if it's occupied, I would not do that, sir. If somebody has belongings in there, I would not walk into the house, no, sir.
Okay. But it's your testimony that if the gate, if you can walk into the side yard anytime you want.
I don't know about any time I want, because the gate was open,
If the gate was closed, would you have walked in?
no, sir.
So you said the gate being open was indicated.
I believe so, yes, sir. I didn't see a wrongful entry on that. I do not. I mean, it may be, but that's my opinion.
Did Mr. Walshine ask you to leave?
Yes, while he was videotaping me.
Did you tell him that you can just get the police and they can bring you back and
I
rescue?
said if I have to, I'll bring the police back, yes.
Would the police need a warrant?
I'm not sure, sir. I don't know that part of the law.
But it's your opinion, your testimony here today that you don't need a warrant or permission to go into someone's yard or rear yard.
I don't believe I need a warrant, no, sir.
And that's what you believe.
I don't believe so.
Yes or no, do you or do you not?
I do
Do
not.
you have the authority as a building inspector to go
Objection,
into
Your Honor.
somebody's
It's been
rear yard or
asked
side
and
yard
answered.
without permission?
Mr. Lemon, I think he has answered that question several times.
I have nothing further.
All right, thank you. Any redirect?
Yes, thank you, Your Honor. Mr. Miller, when you approached the gate, what did you see going on at the property?
I saw people cutting pavers, installing pavers. I was at the gate, and I could see the people working. None of them spoke very good English, so I had a hard time communicating with them. So I asked them where their permit was. The one gentleman got on the phone, I guess he called the owner. The owner showed up. He had paperwork in his hands, said, what are you doing on my property, yada, yada. He says, he's asking me to leave. I said, I'm here just to find out where your permit is for the pavers.
So when you first got there, the property owner wasn't present?
No, ma'am.
And was the folks doing work, were they inside the gate, behind the gate, or?
Yes, ma'am, they were inside the pool area, inside the closed area where the gate was propped open from the windows.
Okay. And when you got in there, you then also talked to the property owner?
After the property owner arrived, yes, ma'am.
Okay. Did you have advised the property owner of anything regarding the pavers at that time?
Yes, ma'am, I handed him the stop work order. I explained to him that he needs to get a permit out here. He said, you need to leave my property. He was really threatening about it. I said, okay, whatever, I'll get a police officer out here if I need to, and he will escort me in. That's all I said. That's how that worked, and I left.
Thank you. Nothing further, Your Honor.
All right, Mr. Lemon.
Redirect. Wait. Why not? That's what I'm saying. So you just testified that standing at the gate, you could see around the side of the house to this alleged paperwork. Is that correct? You could see from the gate?
See what alleged paperwork, sir?
Paperwork.
Oh, yes, most definitely.
So you could see people working on this pool deck and putting papers down?
Yes, sir.
From standing at the gate, not as
Yes.
you walk through it?
Yeah, stand at the gate.
Do you know how long the side of that house is?
Yes, sir.
How long is it?
It's longer than normal, I guess. You tell me.
I
how
just
long it
asked
is.
you how long it was. You
I
said
don't know how long it is, sir. What difference does it make how long it is? I have good sight. I can see people.
You have x-ray vision, you can see through the
Oh, I
building.
didn't say I have x-ray vision, sir.
So you can see through the building.
Maybe you can, I can't.
I have nothing further at this time.
Thank you.
All right, any further witnesses from the town?
Your Honor, we also have the town clerk to testify. She can provide some background on the prior violation, which in the notice in this case.
I object to that. We're not here for a prior violation. We're here for this violation. He's not here for construction materials on the driveway. He's not here for anything else but allegedly doing work without a permit. It is entirely inappropriate to hear testimony about something that has nothing to do with this violation. This violation is about work without a permit. not storage of construction material on a driveway, or that Mr. Walshine's a bad guy, or anything else.
Your Honor, the purpose of the town clerk's testimony will be to establish the reasonableness of ordering immediate compliance in the NOV for the work without permit, because the original case that was started was for the very construction materials that are at issue in the work without permit. So we would be establishing that the property owner was well aware of the issue with having construction materials at his property, and that was the basis for the NOV for work without a permit. And so the reasonableness of ordering someone to immediately come into compliance pertains to the fact, since that well before the issuance of the NOV for the work without permit, he was specifically put on notice by the town of the issues with the construction materials.
Again, that's immaterial. Each NOV has to stand on its own. 162.06 subparagraph 2 doesn't parse, it doesn't suggest, it says you must provide a reasonable time to comply. And it has to be contained in this notice of violation, not a previous notice of violation for a different code violation. This violation is required to stand or fall on its own.
What's the town's response to that?
Your Honor, the determination of reasonableness is different in every case. Some cases, reasonableness might be well over 180 days. In this case, the property owner was put on notice of the construction materials. He was given a stop work order to stop work. He was then finally issued the notice of violation for work without a permit. And that's part of the town clerk's testimony as to what would be reasonable notice in this case, the background of this case, and also the fact of prior conversations with the property owner who came in to apply for the permit.
And those conversations were had with Miss Avery?
Yes.
Okay, is there reference in any of the documentation to the previous stop work order in this case?
I believe the affidavit, yes. If you look at the NOV, the first couple lines, working without a permit in Florida Building Code 105.1, please apply for permits for all construction that is occurring at the property. You are notified November 22nd, 2024 to stop working. You will need to obtain a permit in order to work on your property.
All right, I'm going to allow Miss Avery's testimony. I'm going to ask that specific details about whatever the underlying case is that's being referenced, the old case that is no longer, that your testimony not include specific details about that. Limit your testimony to relevant information as it pertains to this notice of violation, okay? State your name for the record.
Kelly Avery, town clerk.
Thank you.
Because it had been, and it has to do with the previous dismissed case, there was construction material that was found in the front. I guess it was observed that it had been little by little been, disappearing, so they knew something was going on. I believe this was reported by one of our officers to the building official, and with the suspicion that work was being done. That is when I believe, I was not there that day, but I believe that's when the building official then sent out the building inspector to go look at that. Then I was told that that's what they found, and then the notice of violation was issued based on the fact that we had already given time to remove the building material.
All right, town attorney, any further questions for this witness?
Ms. Avery, at any time did you talk with the property owner?
He had emailed when he got the first warning and notice from the officer about it, and then he did public records requests on who came onto the property and asking who the inspectors were and their qualifications. He did come in at one point after this notice of violation had gone out, and asked for a building permit, information, and I gave it to him. But that was probably about the only extent of communication I had directly with him.
Okay, and at that time, did you guys have any discussion about the work that was being done at his property?
No, he mentioned in his emails that he had a permit already, but it wasn't for this. It was for windows and doors.
And so when you say this, do you mean the pavers?
Correct.
Okay. Did you have a conversation about the pavers at all?
Only when he came in asking for building permit documents.
And did he mention the pavers, or did you mention the pavers?
He just said, what do I need for papers? And I just kind of told him what building documents he needed for that. And that was pretty much it.
Okay. Nothing further, Your Honor. Thank you.
Go ahead, Mr. Lohman.
I don't have anything.
All right, just one follow-up question for the clerk. When you spoke to the property owner, when he came, did he come to town hall?
Yes.
When was that?
Gosh. I honestly don't remember the date.
Do you remember if it was before or after the notice?
That was after the notice.
Okay, I'm just trying to get a sense for the timeline here. Okay, thank you. Okay, any further witnesses that the town intends to call?
No, Your Honor.
Okay. Anything further that the town would like me to hear? I guess I'll ask what the town is seeking today in terms of remedy.
Your Honor, so since this case has been cited and it's been continued, I believe typically for a paver permit, and I'm sort of looking to the clerk on this, that the permit can be issued fairly quickly as long as there's everything in the permit, because you may need Department of Health approval, assuming it can be issued within a week's time.
Usually if everything's submitted and everything's there that we need, anywhere from a week to 2 weeks.
Okay, so given that, Your Honor, we would ask for 30 days to come into compliance.
In the event of non-compliance?
And we would ask for $100 fines per day, plus the town's costs, which are set forth, I believe, in a exhibit to this. Are the costs included?
Yes.
Yeah, oh, there they are. Thank you. $173.64.
All right, the town then rests its side?
Yes, thank you, Your
All
Honor.
right, Mr. Lohman, go ahead.
Again, as it relates to the Fourth Amendment issue, Mr. Miller is not allowed to walk into the rear of the property because the gate's open. The case law is crystal clear on that. In Florida versus Jardines, it's a U.S. Supreme Court case out of 2013. It's 569 U.S. 1, 2013. They held that the curtilage of a home is a constitutionally protected area, and the physical entry onto this area without a warrant or consent for investigative purposes constitutes an unreasonable search. That's what occurred here. It was reaffirmed in Florida, in the city of Palm Coast, as it relates to code enforcement officers. I also, again, I'd already made the arguments as significant issues as it relates to the issuance of the notice of violation in of itself, because it wasn't based upon personal knowledge. It wasn't based on personal observation as testified to by the code officer. It was issued based upon someone else telling him that there was a violation. He didn't personally observe any work being done. That's what it says, personal observation. His investigation was comprised of talking to other people, asking them what they saw. And they don't have a sworn affidavit here. There's no sworn affidavit or testimony by Mr. Palacios saying that he told Mr. Shaheen this, and that's what Mr. Palacios saw. And again, I can't cross-examine Mr. Palacios because he's not here. And irrespective of when my client knew or didn't know about the violation, which we certainly know it was on December 2nd, because that's when he received the notice, immediately isn't reasonable, as evidenced by the fact that the town just said if you find him in violation, they'll give him 30 days. So how is immediately reasonable if the town is amenable to 30 days now? you can't possibly comply immediately. You can't. Immediately it's right now, and then it's a second later, and it's a second later after that. There was no opportunity after this notice to comply, and that's what's required under the law. What happened before? Who shot John? He said, she said, construction materials in the driveway. It doesn't matter. What matters is what's in the paperwork, in the documentation. If my client has to abide by the Florida statutes and the Florida Building Code and the town's code, so does the town. The procedures in Chapter 162 are not a suggestion. They're not you can kind of do it. No, you're required to follow them to the letter so that you are providing proper procedural due process. And that did not occur here. There was not sufficient time given in the notice of violation.
Okay.
The notice of violation is also kind of vague. It just says work without a permit. Didn't specify what work was being done. Based upon the testimony and everybody's, and things been presented here, it's apparently pavers, but that's not what was contained in the notice of violation. And as it relates to the Fourth Amendment issue, I'm gonna call Mr. Walshine up here to testify.
Okay. All right, you can go back to your seat, sir.
Okay.
Your Honor, if I could respond to counsel's argument.
Make a note if you would. Let me hear the testimony of Mr. Walshine, and then you can follow up at that time. I just want to give Mr. Lohman the opportunity to present his case before there's any additional response from the town. Your name, sir, for the record?
Jay Walshine.
And you're the property owner?
Yes.
And you were sworn, correct?
Yes.
You raised your right hand when I swore everybody in? Okay, go ahead, Mr. Lohman.
Mr. Walshine, you own the property at 81 Island Drive, correct?
Yes.
Are you familiar with the property and its layout?
Yes.
Do you know the gate of which Mr. Miller is speaking that you went through?
Yes.
Was that gate open or closed?
No, it was closed.
When you're standing at that gate, either just inside it or just outside it by a foot or two, is the area where the alleged work where the work was alleged to be taking place, is it visible from there?
As some of you are aware, I'm an ophthalmologist and I used to teach optics. It is impossible, based on that angle, to see into the backyard with a 14-foot hedge height and the size of the 26-foot walls. You would need x-ray vision to see into that back.
Was there work being done on the property on 11/22 as it being alleged?
Yes.
What work was being done?
Windows.
Did you have a paper permit for the windows?
Yes. And as you see in the photos, you'll see there's concrete, which was to lay the windows down properly.
Oh, you're referring to the photograph
Titan.
showing the guy walking back and forth to the truck?
The Titan concrete.
Did you call for an inspection for your windows?
No.
Did you ask Mr. Miller to leave your property?
Yes.
Did Mr. Miller tell you that he could just come back and have the police escort him on the property?
He was very threatening. And there's a video where he says, I don't need your permission to come into this property. And if you don't let me on the property, I will get the police and make you open the door and have you come onto the property.
Did you tell Mr. Miller that he was violating your Fourth Amendment rights?
Multiple times.
Did he eventually leave the property?
He did resistantly.
I have nothing further.
All right, does the town have any cross-examination for this witness?
Yes. Mr. Washington, do you have the video?
Yes.
Okay, can we see the video?
Sure.
And Mr. Lohman, you're aware of this video?
It's not on
Yes,
his
ma'am.
phone, I'm
Okay.
sorry. It's not on the phone.
Okay, so I can't see the video.
You don't have the video with you?
It's not on his phone.
Okay. All right, so no video. So we would object to any testimony regarding the video to be hearsay. Were you present when Lewis Miller came to the property as the town's building inspector?
Yes.
You were present at the property.
I was just off the block. I was walking to my other property.
So were you present at 81 Island Drive South when,
100 feet away.
so you weren't at the property
I
yet?
was right at the property.
Okay, you're 100 feet away or right at the property?
Right at the property,
Right at the property. At the curtilage or 100 feet away?
on the street, right there.
On the street, okay. Did you see Mr. Miller arrive?
Yes,
Okay. Who else was at your property?
window construction people,
Okay, only window construction people?
as I recall.
Okay. And what about the pavers in your front yard? Were they part of the window construction?
No.
What are the pavers for?
We have 2 sets of pavers
Okay, what's the first set for?
for the damage that was done to the property on my other property at 119.
Okay, so one set's for 119, what's that address?
Marlin Drive.
Marlin Drive. And at 119 Marlin Drive, are you installing pavers there?
That's what I was requesting a permit for.
Okay, but you didn't get the permit?
Not yet, because they're doing the dock over.
Okay,
It would come afterwards.
but the pavers are now at 119 Marlin?
Yes,
Okay, what about the second set of pavers?
that's the only set of pavers that are in that picture.
You told me there were 2 sets of pavers at your house.
Those are the sets of pavers that are at 119.
What's the other set of pavers at your house?
I can't speak on any other pavers.
You said there were 2 sets of pavers.
I did, but those are not there
Okay, where are the second set of pavers?
at 119.
So they're not at 81 Island Drive South?
No,
Well, what are the second set of pavers for?
I made a mistake. There's no second set of pavers.
Oh, okay, so your testimony just now was a mistake.
I make mistakes.
Okay. All right, so in the photographs that have been presented in this case thus far, is it your testimony here today that you can't see into your backyard from the side of the property?
That's correct.
Okay, nothing further, Your Honor.
All right, anything further, Mr. Lemon, for this witness? Okay. Let me just ask you a couple of questions, Mr. Walshine. I heard testimony earlier from the clerk that you came into town hall to seek, or there was a discussion about getting a permit for pavers. What permit were you seeking from the town?
So going back a little ways, the town forced me to remove construction debris from my house at 119 Marlin. And rather than doing it properly and timely like it should have been done, or allowed to be done timely and properly, which is with a crane, the town issued me a citation stating that it had to be done immediately or within a certain amount of 10 days or 7 days. So we had to get a Bobcat to come in, and the Bobcat destroyed everything in the backyard, including the papers and everything else.
In the backyard of which address?
119.
Okay. I'm trying to get at what permit for pavers were you asking for? Was that for 81 Island Drive or for 119 Marlin Drive?
119. And I didn't specifically ask for a paper permit. In fact, I didn't speak to her in person. I spoke to her on the phone. I said, what do I need? But I said, and that was for 119.
All right. So the photographs that are on the screen right now, those pavers are not on that is 81, correct? That's the address of 81? So those pavers were being stored on that site, but they were for a different site. That's your testimony?
They're actually in my garage at the other house.
Okay. Why were they in the yard of this address?
Delivered to the wrong address.
Okay. How many pallets of pavers were delivered to the wrong address?
5.
Okay. And the testimony that I heard earlier indicates that there was a paver being installed there were pavers being installed in the backyard of 81. That is not accurate?
Not on the 22nd or the December 2nd when he was there.
Okay.
And that's the window truck.
That trailer there?
Mm-hmm.
Okay. Okay. All right, I don't have any additional questions for you, sir. Thank you. Any additional witnesses, Mr. Bowman?
No, ma'am.
Okay.
Your Honor, I would like to recall Mr. Sheehan.
Okay, you can step down, sir. State your name again for the record, sir.
Steve Shane.
Sorry, I mispronounced that.
Go ahead.
Ms. Avery, could you go to the picture that's labeled picture 2? Mr. Sheehan, did you take that picture?
No,
Do you know who took that picture?
no.
Okay. Your Honor, I need to recall Mr. Miller.
All right, before you step down, anything further for this witness?
Did you take any of the photographs?
December 2nd.
Which photographs are from December 2nd?
I believe those.
You believe or you don't?
I, without looking at all my stuff, my phones and everything, I believe that's it. I take 50 pictures a day.
This is sworn testimony. It has to be yes or no. I believe, I think.
Well, there's a lot
hear
of
you,
pictures
Mr. Logan.
there.
I hear you.
There's a lot of pictures, different dates. And I don't have my evidence in front of me, my phone. And,
Do you have your phone with you?
it's in the car, the work phone's in the car, and my iPad, I have to look. But yeah, it's on the property, but I'd have to look.
Okay. Do you recall there being a
But I-
black trailer there when you were there?
I believe so. There was workers. There was activity going on. There was pallets and activity, workers working 100%.
Were they removing things out of the paper pallets?
Yes, there was activity, there was workers moving.
Were they moving the pavers?
Yes, they were moving around activity, there was moving supplies. And I was told to take a picture.
Did you see people taking papers out of the pallets?
I saw activity of supply, people moving and picking up supplies.
Did you see people taking papers out of the pallets, yes or no?
That's in the pallet, yes.
You saw people taking, so now your testimony is you did see people.
Well, there's only two things, there was bags and pavers.
And so I asked you, did you see people taking things out of the papers? You said, I don't know, I can't believe, and then now it's yes.
Well, some stuff out of they were taking stuff out to sit there and specifically look and say, that's a paver. They were taking construction material out of the pallets and walking toward the back. That's my testimony.
All right, anything further?
No.
All right.
Your Honor, I just need to call Inspector Miller back up to the stand.
All right, approach, sir.
And Ms. Avery, can you again show picture number 2? Is there a way to sort of zoom in? Mr. Miller, in your testimony previously, you said that you could see into the backyard from the side of the property. We're looking at a photograph that was taken of the property. Do you recognize this photograph?
No, I do not.
Do you recognize what's depicted in the photograph?
Yes, I do.
Does this fairly and accurately depict what you saw
Yes.
on the day you went to the property?
Yes.
And does this fairly and accurately represent what you saw before you went through the gate?
Well, I saw windows and things on the sides, like I said, but, yes, I did. I looked through the gate and I could see people in the back, yes. And then I'm not an optometrist, but I can see that far.
Okay, thank you. Nothing further, Your Honor.
Anything, Mr. Lohman?
Yes, could we put up the photograph that shows the other side of the property, please? I can't remember, I'm sorry, I don't remember what number it was. That one, that's perfect. Isn't that the gate you walked through, Mr. Miller?
You want to zoom that in so I can see it better? Yes, and also you can see in the back, you can see the pool area.
You can see the pool area.
I could see the white in the back is where they were working when I walked up. See that white in the back, way in the back? Yes, that. That's where they were standing. The guys that were installing the pavers, that's where they were standing. One guy was standing there and the other guys were working on the pavers. And the gate was open.
And you just testified a minute ago that you saw the work on the other side, so it's.
No,
you saw both.
I said you can see the workers from the other side as well, yes. You can see in the back.
And you could see that the workers on the other side, from that photograph, you could discern that they were doing paperwork, not windows.
Oh, didn't take that picture. This is the side that I went in.
And you could see people, your testimony is that you could see through that little crack, you could see people working on paper specifically.
Not people, a person working in the back. I could see a person standing there with a red shirt. Yes, sir, I could.
And you could see them working on papers. That's your testimony? You saw them laying papers, putting them
When I
down?
went back there, I could see him laying papers.
Oh, when
yes.
you went back?
Yes, sir.
Okay, but not
After I
from
entered
there.
No, not from there, but
Okay.
I saw the man standing there at that time, yes.
Great. So you saw a man standing there and that gave you justification. We've already asked this question. Yes. Okay. I have nothing else.
All right, anything further from the town?
Thank you.
All right. So, I need some clarification from the town on what, there are a lot of photos in the case file. Does the town have the dates of those photographs?
Unfortunately, I do not have dates on, they came from several different people. I got them from the police officer that initially went out, as well as when they delivered, and most of it's from the police officer when he first went out. From the first case, we just put them in there to show. Because they basically went together.
Ms. Avery, would it be accurate to state that the photographs were at the time of the notice of violation or predated the notice of violation?
How can she possibly testify to that?
Ms. Avery, how involved are you in the town's community standards hearing?
Very.
And who helps to put together the case files for each case that's brought before the magistrate?
It's a combination of myself and whoever, usually code enforcement or the police officer that's been involved.
And do you provide any assistance in preparing the notice of violation?
Yes,
And do you provide any assistance in the hearings?
yes,
And is it your testimony here today that the photographs included in this case file were either done before the notice of violation was issued in the first case and the notice of violation that's at issue now?
yes. I would say everything from down here and below was all before this notice of violation. The rest of them were all from the previous.
Thank you.
Redirect, crossing out.
Yes, go ahead.
Can you, I appreciate that. In fact, can you tell me the dates that they were taken?
Without me going back and looking at my email, I don't know right offhand. They normally, the people that provided the picture this time aren't normal ones I usually get. Normally I used to get them maybe time-stamped.
Right.
But I don't have them on these, no.
Do we even know who took the pictures?
I'd have to go back in my emails and grab them.
But they're not here today. It's safe to say they're not here today, is that correct?
That would be safe, yes.
Right, so we have pictures that are undated,
But
except
these
the
are-
fact that they have been taken before the NOV was issued. We don't know who took them, and we don't know the date they were
Most likely it's the
taken.
police officer that took these.
Right, but he's not here to testify that he did take it. So again, that's you telling us that the police officer took it.
We could recess and I could go get my emails.
Your email is still hearsay.
It's
You
time
can't testify that he took it, because he emailed you a photograph doesn't mean he took it. I email photographs to people all the time that I didn't take.
All right.
I'd like to make my final argument if I could, just to sum it up briefly.
I'll allow final arguments. I'll ask you to be brief, and I have heard everything you've said, so go ahead and then I'll give the town, do you want to go before or after the town?
I can go after, that's fine.
Madam Town Attorney.
Your Honor, in this case, we presented overwhelming photographic evidence showing that the property at 81 Island Drive South had multiple storage of pilots on the property. And if you look at the photos closely, you can see in those photos that the pavers are slowly disappearing from those pallet boxes. We have testimony from both our code enforcement Mr. Sheehan, officer who testified as to observing supplies being removed from those boxes by people working on the property. We have our building inspector who testified that being on the property and seeing from the side of the property, people in the back working, observing the pallets. Also, even if you were to exclude his testimony based on a Fourth Amendment violation, once he entered the curtilage, there's still sufficient evidence that there was work going on here with these pallets of construction cement, ready-mix cement, and these pallets that they did not have a valid building permit for. Mr. Walshing testified himself that there were two sets of pallets and then corrected himself when he realized that there may not be a second set and has tried to allege that now these pallets are suddenly at the wrong property. Your Honor, the town started this case back in November with the violation for storage of these very exact pallets being stored at the property. Even then, Mr. Walshing was on notice of these pallets being issued. If they were wrongfully delivered, he had an opportunity to remove them off property. He was then advised by the building inspector to stop work, which, as you know, in the Florida Building Code is an immediate stop work and go get a permit process. That was done in advance of the NOV, which was then issued several days later. The exact time frame is noted on the NOV, which would have given him time to come in and apply for a permit and then therefore be in compliance, which the town clerk testified at max would take 2 weeks' time. So by the time the NOV was issued, the property owner had sufficient time to correct this violation. The town's recommendation for the 30 days and to come into compliance is based on the standpoint of your finding a violation today and affording him that 2-week time that the clerk testified to, plus additional time should he need other approvals like Department of Health, depending on where these papers have been set. And that is this case, Your Honor. We believe that there is sufficient corroborating evidence, even if you rule that there's a Fourth Amendment violation, which we don't believe there is. The building official, the building inspector went on the property with an open window and door permit. He saw people working. The property owner testified that he was not on the property. The building inspector therefore went into the back of the property. When he was approached by the property owner, he left. Supposedly there's a video of this. We don't have the advantage of seeing that video, which would probably provide additional information about who was working and doing what, but we don't have the advantage of that, so we can only speculate. So again, we would ask you to find him in violation of work without a permit, give him 30 days to come into compliance, failing which a fine of $100 per day, and the town's costs as stated in the evidence of record.
All right, Mr. Lawman.
Yes, well, we've already talked about the Fourth Amendment violation. It's frightening to me that people don't think that that's a violation. It's probably a good reason that you got building inspectors and building officials traipsing around on people's property without their permission. The case law doesn't say you have to be home. You're not allowed to come on somebody's property and go snooping around in their curtilage just because you want to. An open window permit is not sufficient. That's not sufficient. He wasn't there to do an inspection. You can't just come on the property and say, I'm doing an inspection when there's nobody called for one. He testified and admitted that he wouldn't walk through the open door of the house. Well, even if the gate was open, which there was testimony by Mr. Walshine that it was closed, he's still not entitled to go into the rear of the property. And then he said he saw a guy standing in the rear. Sure, he didn't see anybody working on papers. He saw a guy standing back there working. He didn't see, whatever he saw after he walked through the gate. And assuming arguendo that everything the town is alleging actually happened, that's the reason you have Fourth Amendment protections. The only people that typically really get harmed by constitutional violations are people that, if somebody did something wrong, but in this case, I'm not stipulating that he did. The evidence and the testimony by Mr. Miller is entirely gained by violating Mr. Walshine's Fourth Amendment rights. The notice of violation itself is issued entirely and utterly on hearsay. says, I observed. Doesn't say he could have scratched out personal observation, he didn't. Investigation. Issued this because somebody else told him to. The somebody else that said he observed the violation isn't here. Mr. Walshine was denied the opportunity to cross-examine that person. We don't know who they're here. We don't know who took the photographs. The photographs aren't dated. There's nobody that can swear to those photographs because they didn't take them. Personal knowledge is personal knowledge. It's not somebody telling you that. Signing an affidavit saying, I personally observed because Bob told me, is not personal observation. It's actually perjury. It's not, oh gosh, I made a mistake. And again, the whole point here is not, it's bigger than just this alleged building code violation. This process is set here to protect the residents of the town of Ocean Ridge, all of them. Not just my client, but all of them. It's that way by statute for everybody. And the Florida legislature did this back in the early 70s because everybody had their own little municipal courts and it was goat rope. And so they adopted Chapter 162. They did it, actually the test legislation for it was a special act just for Palm Beach County, 1 year, because we have the most municipalities. And then the legislature said that's working, and they abolished municipal courts and instituted this process. This chapter, especially the part one, chapter 160, section 162.06, other than some of the notice provisions, is almost entirely unchanged since its inception. And it is crystal clear. Regardless of how much time or knowledge you had about something else, the previous violation doesn't matter. This notice of violation has to stand on its own, and he was entitled to receive a reasonable time to comply. Immediately is not reasonable. It's not. It has to stand on its own, and it didn't. He should have been issued an NOV and be told to get a permit. He shouldn't be found in violation here today. He should be issued another notice of violation and given an opportunity to cure it, instead of being found in violation. So then he's staring down the barrel of a repeat violation the next time somebody wants to violate his Fourth Amendment rights and go snooping around his property because they have the impression that work is being done. I mean, the absurdity of that should really resonate with the attorneys in this room. The impression, I could have the impression that you have $1,000 in your trunk that I could want. A cop could have an impression that you have marijuana in your purse, and you may not, but they can't grab your purse and search it because they have the impression. You have the right to be secure in your property and your person. And that was a violation. And then on top of that, we have a legally insufficient notice, sworn to by somebody that did not personally see things, and his investigation is comprised of somebody else telling him what he saw, and then issuing a notice of violation. There's no sworn affidavit by Mr. Palacios. I wouldn't be making that argument if there was. That's the proper way a building inspector is supposed to do a code violation. If a building inspector sees a code violation, they're supposed to then come back to the code officer and then tell them, and then sign an affidavit, and then you issue the NOV. Building inspectors are not allowed to enforce anything other than the Florida Building Code. So that's how it's supposed to be done, but it wasn't necessarily done that way here. So for that reason, I don't think, I think that there is not sufficient grounds to find my client in violation because he was not afforded procedural due process under Chapter 162, specifically 162.06, subparagraph 2. As stated before, this is not a repeat violation under subparagraph 3. It's not a public health, safety, and welfare violation, and it's not a reversible irreparable under subparagraph 4. He was required, it is the law, it's not an option. He was required to get a reasonable time to comply, and they did not give him that.
All right, thank
Your
you.
Honor, your brief rebuttal.
Go ahead.
Your Honor, I just want to restate that we're not under strict rules of evidence here. And what the notice of violation states is that the undersigned certifies and swear that he has just and reasonable grounds to believe and does believe the violation based on personal observation / investigation. That does not mean you can't use hearsay to establish your notice of violation. And there's no case law that says you cannot use hearsay, but what you do need is corroborating evidence when you come in to this quasi-judicial hearing to establish that we've met our burden by a preponderance of the evidence to establish that a violation has occurred of work without permits. Even if you were to deny the building inspector's testimony, we have photographs and we have testimony from our code inspector officer that work is being done at this property without a building permit.
Let me ask a couple of questions of the town. The issue I'm having is the photographs. Why is Mr. Palacios not here? Why did Mr. Palacios not submit a sworn statement as to what he observed? I'm not sure that Mr. Lohman is not correct in that I haven't heard anything today that I have testimony that nobody knows the dates of the photographs that are attempting to be entered into the record. The testimony of the town's witnesses have not confirmed whether any of those photographs were taken by any of those witnesses. I'm not sure, without dates of photographs that directly tie to the notice of violation or testimony to the timeline at which those photographs were taken, apart from the issue of people going into the backyard of the property, which I'm not even going to get into, because there's no video of that. There is testimony, but I'm not even going to get into that. The photographs that I do have in the case file appear to be from the public view from the street. But there isn't evidence on the record as to when those photographs were taken, who took the photographs. Is there any response to that?
Yes, as to that, I think that gets back to the whole idea of the strict rules of evidence. You know, obviously in a court of law, you ideally have the person who took the photographs to testify as to who took the photographs, when they took them, yada, yada, yada. However, if you have photographs depicting the property, which nobody has object to, even the property owner when he testified that these are not pictures of the photographs, if the photographs accurately and fairly depict the property, then our evidence would be that it satisfies our burden of proof, which is the preponderance of the evidence, that there are pavers at the property, and as Ms. Avery did testify, that these were taken either prior to the initial notice of violation for storage or issued after that time frame, but before the current notice of violation that's at issue in this case. So what we're talking about here is really a 2-month time frame. That's what she testified to. Then you don't have to prove beyond a reasonable doubt as to who took the photographs and the exact date of the photographs.
All right, what's the town's response as it relates to the immediate compliance on the part of the respondent and the legal sufficiency of that under 162?
Your Honor, as was testified in this case, the inspector has to provide a reasonable time for compliance. 162 doesn't talk about what is reasonable based solely on issuing that NOV that day, because reasonable can mean different things. And in this case, our position is reasonable is based on the fact that this property owner was previously put on notice through a notice of violation, through a conversation with the building inspector, that there was work being done on the property that predates the date of that NOV.
There was actually
So
no
hold on a
testimony.
second, Mr. Lohman. So our position is there is no case law and there is no dictate in 162 that reasonable has to stand completely on its own. It has to be reasonable. And that differs in case to case. Because some cases, depending on what the violation may be, you may have to give them 180 days because they've got to go through a major permit process to get it done. In this case, town clerk testified maximum maybe 2 weeks to get a paper permit if you get everything in order. So when he was first advised in the prior case of these being out there being stored, or at least when the work order was issued on November 22nd, that would have given him sufficient time to come in and at least apply for a permit or start the process.
But if the testimony of the town's own code enforcement officer is that immediately is not a reasonable time, and the testimony is that it takes 2 to 4 weeks to get a permit, if you can't physically comply within the time specified, I think there's a very strong argument that that's not a reasonable time to comply.
I appreciate that, and I agree that yes, you can immediately apply for a permit, but that's not the facts of this case. The facts of this case are that on November 22nd, the property owner was advised by the building inspector, you need to stop work and apply for a building permit. and nothing was done except for the conversation with the town clerk about applying for a paper permit.
And again, that's all well and good. But the NOV wasn't issued until December 2nd, and the NOV says immediately. So irrespective of that, my client was formally put on notice he was being cited for this code violation on December 2nd. Mr. Miller didn't testify that he was citing him for a code violation. He purportedly issued a stop work order. And as you just pointed out, 2 to 4 weeks is reasonable. Mr. Walshine was never given the opportunity to comply to this violation order. Previous violations, what he knew about this and that in construction, doesn't matter. We're not here on those issues. We're not here on those issues. We're here on this violation. And this violation it is legally insufficient. I agree with Ms. Gatto, absolutely. Reasonably does vary. And sometimes you'll give somebody what you think is a reasonable time on an NOV, and then they'll contact you and you go, wow, they need more time, and it's reasonable to give them more time. Sometimes it's not. But there was no time given. He was coming to this hearing as soon as that was issued, which again was also a violation, because 162 doesn't allow you to bring somebody immediately to a hearing unless it's a public health, safety, and welfare violation, a repeat violation, or irreversible, irreparable. No one has testified at all here today that this violation constituted any one of those 3 potential violations.
All right, I have heard from both of you, I've heard from everybody. All right, this is the speak now or forever hold your peace portion of the hearing.
I don't know about Ms. Gatto, but I'm thinking, Gatto, I'm sorry. I think I'm afraid to the sound of my voice, I'm worn out.
Yeah. Your Honor, nothing further from the town at this point.
Right. Thank you. I appreciate both sides' argument. This is a tricky one. This is a tricky one because I think there are sufficient facts to, the adage that if it walks like a duck, it quacks like a duck. It probably is a duck. My inclination is that there was probably a paver deck being installed in the backyard by your client. However, I do not think, based on the evidence that is before me today, that I have sufficient evidence to find you in violation. I think it's a significant problem that the photographs are not dated. There's nobody here to testify as to who took the photographs, without even getting into the issue of personal inspection at the rear of the property. I think there is also an issue with the notice of violation and who observed or did a personal investigation. Now, I'm not saying that a personal investigation wasn't done, but I am saying that the testimony that I've heard from the town's witnesses today is not sufficient for me to find that the code enforcement officer had sufficient knowledge to issue the notice of violation. I also have an issue with the fact that there's a stop work order that's referenced in the notice, but it's not presented as part of the evidentiary package for today's hearing. The notice of violation doesn't specify what the stop work order was issued for. The building official is not here. So I think from a paperwork perspective, and Mr. Lohman, I'm going to dismiss this case because I don't find that there's legally sufficient service as it relates to the person having actual knowledge of the site that existed at the time, whatever time those photographs were taken. So I am going to dismiss the case 2024-029. I'm sorry that it took us a while to get through all of that for that to be the outcome. I will put you on notice, Mr. Lohman, and your client, that it's not to say that the town doesn't have the evidence, but as I sit here this morning, I do not have the evidence to find either a finding of sufficient legal service for this morning's hearing or a finding of violation for the work without a permit that's alleged by the town. So I will dismiss 2024-029. You'll get an order that dismisses that because I cannot make a finding on service. I will not make a finding on service. The order will strictly say that the case is being dismissed, okay?
Yes, ma'am.
Thank you.
Thank you, Your Honor.
All right, anything else before the magistrate?
I think that is it. That concludes our agenda.
Thank you. I'll conclude this hearing at 11:49.
Thank you.
Thanks. You're fired.